Hey, because I have not seen this in the news, I'm just going to go ahead and share this. This is from the United States Supreme Court. There was an action, and I can't seem to find it anywhere, right? I don't think that it's been released yet. There was an order that was issued just today. So this is the matter of there was somebody fired by the current presidential administration, and it was a temporary restraining order was issued, and so they filed an emergency docket to the United States Supreme Court, and they held it in abeyance until February 26th, which is today, and like literally a few minutes left of it on where I'm at. And so there wasn't anything in news because something should have happened today on this particular issue. When they held it in abeyance, there was 4 judges involved, and they were split. 2 dissented and 2 would have granted. So this is what happened, and it was granted until March the 1st. So this is a letter from the United States Department of Justice, for those who are following this, right, of the Office of Solicitor General. It says, Dear Mr. Harris, on February 16th, the government filed an application to vacate the district court's temporary restraining order, reinstating respondent as special counsel after the president had fired him. On February 21st, this court issued an order holding the application in abeyance, meaning the United States Supreme Court, appealing the lower courts, federal courts, and until February 6th, which is today, when the temporary restraining order was set to expire. So, today, after a hearing on respondent's motion for preliminary injunction and cross motions for summary judgment, the district court extended its temporary restraining order until Saturday, March 1st, 2025, so that it could give close consideration to all the pleadings submitted by the parties and complete a written opinion. So, at this point, the temporary restraining order is upheld until March 1st. So, in the meantime, the harms to the executive branch from the district court's temporary restraining order have become even more concrete. The same day that this court held the government's application in abeyance, respondent filed administrative actions before the Merit Systems Protection Board challenging executive agencies' firings of 6 probationary employees. See the United States Office of Special Counsel Dellinger's statement on request that the MSPB stay terminations of probationary employees. Respondent sought an immediate 45-day stay of those firings, while my agency continues to investigate further, and announced that he is considering ways to seek relief for a broader group of employees. Although respondent had told this court that he is an inferior officer subject to MSPB supervision, he told the MSPB that the board must grant the special counsel's request for a stay unless the special counsel's claim is inherently unreasonable. U.S. Special Counsel initial request for stay of personnel actions. So the stay request is inherently unreasonable. The stay order at 3, respondent then announced these stays represent a small sample of all the probationary employees who have been fired recently, so our work is far from done. Agency leaders should know that the OSC will continue to pursue allegations of unlawful personnel actions, which can include asking MSPB for relief for a broader group of fired probationary employees. U.S. Office of Special Counsel grants stay of probationary employment terminations. That was yesterday, February 25th. In short, a fired special counsel is wielding executive power over the elected executive's objection to halt employment decisions made by other executive agencies. The MSPB, the entity that respondent argues is responsible for supervising him, is deferring to his stay request so long as the requests are rational. The MSPB, moreover, is being led by a chairman who has herself been fired by the president, only to be reinstated by a district court, ordering that the fired chairman shall continue to serve as chairman, even though the applicable statutes purport to grant tenure protection only to MSPB members and do not restrict a member's removal as chairman. Those developments underscore the grounds for vacating the district court's order. The government respectfully asks that this court, at a minimum, continue to hold the application in abeyance if the court does not grant it now that the temporary restraining order has been extended. Once the district court issues its final decision, presumably on March 1st, it may become necessary for the government to request further relief, at which point the court could dispose of the present application along with any subsequent application. I would appreciate if you would circulate this letter to the members of the court. Sincerely, Sarah M. Harris, Acting Solicitor General. And then to the people that, here it is. And then the order, United States District Court, it was, file stamped on the 26th. As of February 7th, Plaintiff Dellinger was the special counsel of the Office of Special Counsel, appointed by the President, confirmed by the Senate, identified as an assistant to the President, Director of Presidential Personnel Office, informed plaintiff his position was terminated without identifying any reason. February 10th, plaintiff sued to challenge the purported termination, moved for temporary restraining order. On the date, the court entered a short administrative stay, preserving status quo, while the parties briefed the matter, citing authority defining status. So this is the motion, which I'll just put this in the link in the description if you're wanting to read this. I'm not trying to make this a long video, but I just wanted to give an update on this particular case because I haven't seen anything in the news. I'm just like, I don't know, maybe it's because that the order that they issued today has not been released to the public. I can't imagine that because, I don't know, sometimes they get stuff, but they got a copy of it. I mean, I don't know why the news, this is not in the news. But anywho's, on another note, there was one of the judges that Musk threatened to impeach, demanding his impeachment, which is not going to happen. He gave in. That was Justice Bates, and he basically kind of sort of granted him full access to sensitive data. That happened today. Don't really see that in the news either. He said didn't really give it a confirm, but basically said that it's plausible that he is a federal agency. So that's the first sign of any federal district judge calling Doge a federal agency. That's problematic, but this is something that will make it all the way to the United States Supreme Court. I'm trying to follow these cases to make sure that they do make their way up to the United States Supreme Court, just so that, you know, they don't just sit and just allow some new rule of law to happen. Because I personally believe that Congress and their authorities, the checks and balances are so important in our country. And we can't just, no matter who you vote for, I'm not okay with any president taking the power away from Congress. It's just a very slippery slope for our country. I want the best for our government, but I want it to be done by the rule of law, right? So, because otherwise, you know, if you take away the rule of law, it can just be, oh my gosh, I don't even need to go there, right? So, this will be battled out in the courts. And right now, from what I can see, there's division even in the courts. Like, they're split right down the middle on this particular issue. But, you know, we just keep it in prayer that the rule of law will be protected in our land. And anyways, yeah, so that's what's up with this case. If you've been following it, the February 26th abeyance was extended. And so he remains employed, basically. Yeah. So anyways, that's it for this one.